Unit 7, Real Estate Brokerage and the Law of Agency. Introduction to Brokerage and Agency. The nature of real estate brokerage services, particularly those provided in residential sales transactions, has changed significantly over the years. Through the 1950s, real estate brokerage firms were primarily one-office, minimally staffed, family-run operations. The broker listed the owner's property for sale and found a buyer without assistance from other companies. Then the sale was negotiated and closed. It was relatively clear that the broker represented the seller's interests. In the 1960s, however, the ways buyers and sellers were brought together in a transaction began to change. Brokers started to share information about properties they had listed, which resulted in two brokers or firms cooperating with one another to sell a property. Brokers formalized this exchange of information by participating in multiple listing services or MLSs. By increasing exposure to potential buyers, the MLS expedited sales and became a widely used industry service. Unfortunately, confusion can quickly arise over whom the broker represents in these co-brokered transactions, where two or more competing firms cooperated to bring about a sale. For example, ABC Realty would have the listing and represent the seller, but XYZ Realty would bring the purchaser to the transaction. With two different brokerage firms involved in a sale, consumers could easily assume that there was a clear division of responsibility. Consumers may think that the broker who had the property listed for sale represents the seller, while the broker who found the buyer represents the buyer. However, this may not be the case. Up until the mid-1990s, it was commonplace in these shared transactions that both brokerage firms and their brokers or salespersons represented the seller as agents and owed all loyalty to the seller, and owed no duties other than honesty and fairness to the buyer. It was not only the public that was confused by this complex relationship. Brokers were confused as well. Often, brokers who worked with buyers felt a closer kinship with their buyers, but had to act in their legal capacities as a representative of the seller. These brokers were sub-agents of the seller and the seller's listing firm. Sometimes this sub-agency relationship was established by local MLSs, which provided for a unilateral sub-agency, a relationship created when a seller listed property with a listing broker or firm. The listing broker submitted the listing to the MLS so the listing could be shared with other MLS members. These MLS members immediately became sub-agents of the seller. The seller became their client or principal. This common traditional view of agency began to erode when a lawsuit was filed in Minnesota that made buyers become aware and concerned about having their own representation. Unit 7, Real Estate Brokerage and the Law of Agency. The Edina Lawsuit. In 1991, Jamie Bukuski, a consumer who was looking for a home in a suburb of Minneapolis, Minnesota called Minnetonka, worked with an Edina Realty real estate licensee to purchase a home listed for sale with another Edina Realty agent. When she asked the broker with whom she was working if the home she was interested in purchasing had a sprinkler system, she was told yes. She purchased the home without having an independent inspection performed. As it turns out, Jamie's home had no sprinkler system. She turned to an attorney, who initially advised her to avoid litigation since the costs of a lawsuit would far exceed those of installing a sprinkler system at her expense. But Jamie continued to press her point. She was sure that the broker she had worked with had her best interests at heart and should have negotiated on her behalf and advised her to obtain inspections. Jamie's attorney advised her that in fact all agents work for the seller, not for buyers. Since Jamie's broker was working for the seller, but had given the impression that the broker was working for Jamie, Jamie's attorney reasoned that Jamie was the victim of undisclosed dual agency, a relationship that must be consented to by both parties. A class action lawsuit ensued. 20,000 other Edina Realty consumers also claimed that they had been victims of dual agency and filed a $250 million lawsuit against the brokerage firm. Those suing asked the court to refund the estimated sales commissions Edina Realty earned on an average 6,000 in-house transactions each year over the 6 years covered by the litigation. Edina Realty was one of the largest real estate brokerage firms in the country at the time of the litigation, so the lawsuit gained a significant amount of public attention in the media over those ensuing months. The initial lawsuit snowballed into 3, including a suit brought by the United States Department of Justice, charging Edina Realty under the Racketeer Influenced and Corrupt Organizations Act, commonly referred to as the RICO Act, and usually used to prosecute mobsters. RICO is a United States federal law that provides for extended criminal penalties and a civil cause of action for acts performed as part of an ongoing criminal organization. The central issue for the courts to consider became, how much explanation do real estate agents owe customers about their legal relationship? In February of 1995, judges approved settlements worth a combined $19.9 million, ending 3 lawsuits. Edina never admitted any wrongdoing and maintained that it acted lawfully at all times. Such misunderstandings ultimately led buyers to question exactly how their interests were being protected. This helped spur a growing trend in which buyer consumers began to demand that their rights be protected so they could make informed decisions. State legislatures also acted to require that real estate licensees more candidly disclose various agency relationships to consumers. Today's consumers are much more likely to receive information about agency relationships early in their dealings with brokers. They are also likely to have much more choice in whether they are going to be represented or not. In many states, lawmakers have departed from the common law doctrine of caveat emptor, or let the buyer beware, and toward greater consumer protection. Buyers seek not only accurate, factual information, but also advice, particularly as real estate transactions have become much more complex. Buyers view the real estate broker as the expert on whom they can rely to guide them. Today, most buyers seek and obtain representation. Though North Carolina is still considered to be a caveat emptor state where buyers should beware, buyers can trust professionals, even those who represent buyers, to be honest and fair in their dealings. Unit 7, Real Estate Brokerage and the Law of Agency. The Law of Agency. The concept of agency, namely a principal who authorizes someone else, known as an agent, to conduct certain business on behalf of the principal and thereby bind the principal, dates back to the early days of England. The resulting law, which evolved over time, is known as the common law of agency. The basic framework of the law that governs the legal responsibilities of the broker to the people the broker represents has not changed. However, its application has. The law of agency is a common law concept, meaning law from the judgments and decrees of courts as opposed to the legislature. It is being widely replaced or modified by state statute in many jurisdictions, but not in North Carolina. However, in 1995, the Edina case prompted the North Carolina Real Estate Commission, NCREC, to revise its agency rule to require licensees to provide specific agency disclosures, in writing, to buyers and sellers at first substantial contact, in an effort to inform and protect the public, as well as to help the North Carolina licensees avoid the type of liability Edina Realty incurred for practicing undisclosed dual agency. The Edina case also motivated brokers to reevaluate their services. They choose whether they will represent the seller, the buyer, or both, if permitted by state law, in the sale or rental of property. They also must decide how they will cooperate with other brokers in a transaction. Since the Edina case, the brokerage business has undergone many changes as brokers focus on ways to enhance their services to buyers and sellers. The North Carolina Real Estate Commission strongly encourages the broker in charge, or the BIC, of a real estate firm to have a written office policy as to the type or types of agency the firm will practice. The firm is technically the agent in a transaction. The company policy should cover whether the firm will practice seller single agency only, buyer single agency only, or dual and designated agency. Whichever form of representation the firm adopts, the written policy should clearly state that that type of agency representation will be exercised in a specific way. The written policy also should explain how the firm will enter into cooperative relationships among other firms, how it will arrange commission splits, and how it will implement disclosure requirements.